they can read it and then re-instruct them as to how they should consider it, and that is because of this plea agreement, they should examine this witness's credibility with particular care, and they can consider the plea agreement and any hopes the witness may have about receiving future advantages from the Commonwealth. And the reason I want to repeat this instruction is, again, then reminds them that they have to determine whether the witness's testimony is credible or not, that they should consider that the government does not know whether the witness is telling the truth. That is going to be up to them to determine, and that means they have to determine whether the testimony has been affected by her interest in the outcome of the case and any benefits she has received or hopes to receive. And I'm going to leave it at that.
Your Honor, my concern, I have no objection to any of that instruction. It's obviously appropriate, but my concern is defense counsel gave the impression that if the Commonwealth isn't pleased with her testimony, that we can simply declare the agreement null and void, recommend up to the maximum sentence to the court. And he left the impression, at least, that was that. Right? It is clear, it's black letter law, both as a matter of contract law and a matter of due process, that if the Commonwealth were to declare an agreement null and void, the person on the other end of the agreement could petition the court either by a lawsuit, a civil lawsuit. They could actually sue the Commonwealth and say, you are in breach of the contract, right? And you have acted arbitrarily and capriciously and without a basis, and I am suing for an injunction to prevent you from doing this. And a judge would then have to hear that claim and make a decision.
And I just do not want to get into those legal niceties with the jury. I think it is true, and you can certainly point out in the plea agreement, it says that your determination is subject to approval by the judge. It basically says you can recommend to the judge certain things,
right.
Thus implying that the judge has to ultimately make the decision. But I don't think it's necessary to describe all the nuances of the law that you've just described. The plea agreement speaks for itself. I think Mr. Shapiro is objecting to me trying to go beyond what it says, and he may have a point there. It speaks for itself. You can point out certain wording in it, and I think he's also pointing out it's the witness's understanding, not necessarily just what the law says, that's important here. And then I will try to reemphasize to the jury how it is they may consider this agreement, and I think that's enough. So,
if I may, Your Honor, I will ask the court's leave that if we can put together a proposal for an additional instruction with citations that Your Honor will consider supplementing that instruction.
You can certainly do that, and this may be something that I would leave until my final instructions at the end of this case, at which time we will have had ample opportunity to think about it, discuss it, argue about it, and make a decision as to whether the jury needs to be given any additional information. So let's bring back the jury, and I will just start out by just reminding them how they're to consider this plea agreement. And I did indicate, I did receive word to the court officer that the juror is fine to continue to 1. I think she appreciates breaking at 1, so that's our plan.
All rise. Please be seated.
Ladies and gentlemen, before I turn things over to Mr. Deacon for some redirect, let me just reiterate the instructions I gave you with regard to the significance of this plea agreement, cooperation agreement, that was just admitted into evidence as the last exhibit, Exhibit 55. The agreement will be there for you to read. Essentially speaks for itself, even though there has been some questions asked about it. And it does mean that you should examine Ms. Bond's credibility with particular care because she's entered into that plea agreement. And that means that in evaluating her credibility, you should consider that agreement and any hopes that she may have about receiving any future advantages from the Commonwealth. It does mean that you must determine whether her testimony has been affected by her interest in the outcome of the case and any benefits that she has received or hopes to receive under that agreement. You should also consider the fact that even though the agreement talks about the witness giving truthful testimony, the government does not know whether the witness is indeed telling the truth. Ultimately, it will be up to you to decide whether Ms. Bond is telling the truth in this trial. So with that, Mr. Deacon, I'll turn things over to you.
Thank you, Your Honor.
I guess we should have all the exhibits in a pile for everybody to access. I think they're, Mr. Shapiro, if you have any exhibits in evidence, maybe you should put it up front here so we can have everybody able to access them. Hold on just a minute.
Ms. Bond, good afternoon.
Good afternoon.
When Mr. Shapiro left off asking you questions, he asked you about the cooperation agreement that you had entered into with the Commonwealth of Massachusetts. Do you recall that?
Yes. Yes.
And what is your understanding of what it requires you to do?
To be truthful with the DA.
And just the DA or anyone else?
Everyone.
And what is your understanding about what will happen if you in fact are truthful with everyone?
That I will have a sentence of time served, and then I will do 2 years probation.
And were you aware when you actually, this is now in evidence, Your Honor. I'm publishing page 2 of Exhibit 55, the cooperation agreement. And did you read this agreement before you signed it?
Yes.
Did you read the sentence that says, should the district attorney declare this agreement to be null and void because the information or testimony provided by Ms. Bond is not complete and truthful, the district attorney may recommend that the court impose any lawful sentence on Ms. Bond as a result of her guilty plea? Did you understand that?
Yes.
And what is your understanding as to who would ultimately decide whether to re-sentence you or not?
You, and I would assume the judge and jury. I'm not.
When it says the district attorney may recommend that the court, do you understand that to be the judge?
Yes.
And you're also aware that if the district attorney were to believe that your testimony was not complete and truthful, you could be prosecuted for perjury, as Mr. Shapiro asked you. Is that correct?
Yes.
Ms. Bond, Mr. Shapiro asked you quite some time ago now about investigations that the Department of Children and Families conducted into your family, meaning you and Bella,
Yes.
in 2012 and 2013. Do you recall that
Yes.
line of question? And you testified that at the end of assessments, they took no further action. Other than conducting the assessment, they didn't take any further action. Is that right?
Correct.
Your Honor, at this time I would move to introduce the assessment worksheet face pages, which are already exhibits. And I'm sorry, I should know which exhibits they are, Your Honor. If I don't, but we'll look it up quickly. But in addition, attached to them, the conclusion sections of the assessments.
I think this is just show it to Mr. Shapiro. I think we discussed these documents already. I I believe.
I can supply them a legible copy if they're reading.
Okay, so although that might duplicate 1 or 2 pages of an earlier exhibit, why don't we go ahead and mark it all together?
Thank you, Your Honor.
Okay.
And Your Honor, defense counsel raises a good point that I think the last page of the second document is difficult to read because of a copying error. So I reserve the right to just supply a more legible copy down the line.
Yes, we'll do that.
Exhibit 56?
Okay.
Actually, 2 exhibits.
Exhibit 56 and 57?
Yes.
And these are DCF records, Mr. Deacon?
Yes, Your Honor.
That relate to an earlier exhibit.
2 earlier exhibits, I think, Your Honor. And Ms. Sexton, it's exhibit, thank you, Ms. Sexton. Exhibit 37 and 38, Your Honor. Ms. Bond, I believe you testified that the first investigation began, or investigation and assessment began when Bella was only about a month old, is that correct?
Yes.
And if I suggest, well, let me ask you this. I'm going to show you Exhibit 56, the assessment worksheet page. It indicates that the assessment in that resulting from that investigation began on September 24th, 2012 and ended on November 29th, 2012. Do you see that?
I'm sorry, say that again, I was reading, I'm sorry.
Sure. If you notice on the exhibit, and I can zoom in a little bit.
I can read it. Yes.
Do you see that it indicates that the assessment began on September 24th and ended on November 29th?
Yes.
And I'm going to ask you, if you would, to read, first of all, the assessment conclusion at the top of the conclusion section.
Okay. You want me to read it aloud?
Yes, please.
Oh, I'm sorry. No further agency involvement.
Is that your memory of what happened after the assessment?
Yes.
Is that in fact what you testified to some days ago now about what happened as a result of the assessment?
Yes.
Turning to the next page, which for the record is date stamp 005563, ask you if you would to read the conclusion comment.
Conclusion comment. Though Rachelle is not eager about working with DCF and services being offered outside of the shelter, Rachelle is meeting with her PO, psychiatrist, and therapist.
Can you slow down just a bit and speak up just a bit?
Want me to start over again?
No, that's okay.
Okay.
Get up in there.
She has remained at the shelter since her admission in May of 2012. Rachelle meets with her case manager, the housing specialist at the shelter, and eventually worked with DCF. All of her toxic screens have been negative. Bella is up to date medically and working with Healthy Baby, Healthy Child. None of the collaterals have any protective concerns for Bella while in Rachelle's care.
And then it repeats no further DCF involvement at this time?
Yes.
Showing you Exhibit 57. Date stamp number here, pardon? Oh, 005649 is what I'm showing you right now. And that's another assessment worksheet you testified some days ago that investigation began when Bella was around 1. Is that right? Or 10 months, I guess you said?
10 months, I think it was, or 11.
And do you see there that the assessment indicates that the assessment was assigned on July 1st of 2014 and completed on September 4th, 2013?
Yes,
And do you see a few lines down, the assessment disposition?
yes.
What does it say?
No further agency involvement.
I'm going to show you the next page, actually 2 pages down the line, which is 005663. I apologize to everyone for the difficulty with the copying. We'll supply a surrogate exhibit for this page. But if you would, please read the conclusion comment to this assessment.
Though Rachelle is not eager about working with DCF and services being offered outside of the shelter, Rachelle is meeting with her PO, psychiatrist, and therapist. She has been at her current shelter since August 2013 and appears to be in good standing. Rachelle has been working with the housing consultants at the shelter to assist her in identifying housing opportunities. All of her toxic screens have been negative. Bella is up to date medically and working with Healthy Baby, Healthy Child. None of the collaterals have any protective concerns for Bella while in Rochelle's care.
And then it indicates, again, no further agency involvement at this time.
Yes.
Ms. Bond, Mr. Shapiro asked you a number of questions about a statement that you gave to the Massachusetts State Police on September 18, 2015. Do you recall those questions?
Yes.
I don't mean you recall every one of them
Right.
specifically, but do you remember being asked them?
Yes, I remember talking to the police.
I'm going to ask you to keep your voice up as nice and strong as you can, okay, and speak as directly into the microphone
Yes,
as you can.
I remember speaking to the police.
And do you remember the defense counsel asking you a lot of questions about that statement?
Yes.
I'm going to ask you, Ms. Bond, to compare the state of your memory today for your daughter's murder with the state of your memory for the same event on September 18, 2015. So to be more clear maybe about the question, do you feel that you have, how would you feel? I'll start over. Is your memory for your daughter's murder clearer today or September, when you spoke to the state police on September 18, 2015?
I would say now.
Why is that?
I was using very heavily. I was under a lot of stress. A lot of traumatic things were happening, and my mind wasn't in a very good state.
Is your mind in a better state today?
Definitely, I'm clean.
Why?
I'm clean, I'm sober. I've had time to reflect on the situation more, talk to therapists more about it.
You were asked quite a number of questions about a cell phone that appears in the records of Mr. McCarthy's cell phone as D's cell phone. Do you recall those questions?
Yes.
Whose cell phone was that? I know you've answered this before, but whose cell phone was that?
Michael McCarthy's.
And did you use it sometimes?
Sometimes, yes.
Did he ever use it?
Yes.
Were there times, well, I think when you were asking, when Mr. Shapiro was asking you questions, he asked you if there were times when Mr. McCarthy's smartphone, his main phone, wasn't working, wasn't functional.
Yes.
Were there times like that?
Yes.
And what caused that, if you know?
The bill wasn't paid.
And what would happen to his smartphone when the bill wasn't paid?
It was shut off.
When his smartphone shut off, did he have another phone that he could use?
The little cell phone.
The one that's been listed as D's cell phone?
Yes.
When I was asking you questions, you testify that you knew the identity of the person who supplied the defendant with heroin, right?
Yes.
And what did you know his name to be?
Cosa.
I'm going to show you entries from the contacts section of Mr. McCarthy's cell phone. Do you recognize the names in the contact section?
Yes.
And what are those names? What do you recognize them to be?
Cosa, the heroin dealer, the dealer.
And it lists 4 different cell phone numbers for an individual named Cosa, or Cosa 2, or Cosa 2 New. Is that correct?
Yes.
Were you familiar at the time with any of those phone numbers?
I remember the 305 one. I knew he had other numbers, but the one that I remember is the 305 number.
305. And why does that one stand out in your memory as opposed to the others?
That one was always constant from the beginning.
And that's the second number on the line down?
Yes.
Did you ever communicate with Cosa directly yourself?
I had gone outside one time. Whenever he'd go get it, I'd be like outside. Once maybe I seen him, not myself though.
I asked you a bad question. My question wasn't clear. Did you ever call Cosa on the phone, text message with him, interact with him digitally?
No.
This time I moved to introduce this as Exhibit 57.
Any objection? Counsel will admit that? Exhibit 58.
Oh, I'm sorry. I apologize, Your Honor. I missed the exhibit. It's 58. Publishing Exhibit 58 to the jury, Ms. Bond, hopefully that's coming up. You said that you recognize a number for Cosa. Can you direct the jury's attention to where that phone number appears in this excerpt from the defendant's contact section?
Line 33, I think it is, and it's the
se-
second one down. That's the number I recognize.
And it starts with area code 305.
Yes. Can I correct something? I have dialed the number for him before. I've done that, but I've never been on the phone with the man.
At this time, I move to introduce as the next sequential exhibit an excerpt from the timeline from the defendant's cell phone.
There is no objection, so admit that?
No objection.
Exhibit 59.
Ms. Bond, I'm going to show you and the jury at the same time an excerpt from the timeline of the defendant's cell phone record. If I can focus it. And can you see the date section of that timeline?
The highlighted part, you mean?
Just the column that has dates and times in it.
Oh, yes, yes.
And do you see indicated there a notice from Metro PCS on June 2nd instructing him to pay, I think it says $60 by June 2nd for the account to avoid service interruption?
Yes.
And do you see that between June 4th and June 17th, there is no activity other than messages from Xfinity Wi-Fi?
Yes.
And in light of that, what would you say that it is likely that that was one of the periods you've talked about when his phone was not working?
Yes.
So from June 4th to June 17th?
Yes.
This time, Your Honor, I seek to introduce as the next sequential exhibit another excerpt from the timeline of the defendant's cell phone record.
That's admitted. Exhibit 60.
Ms. Vaughn, I'm now showing you and the jury exhibit 60, which shows quite a number of text messages on the afternoon of June 25th, 2015, from the defendant's cell phone to a number 305-890-2059, which is associated in the phone, as we've seen earlier, with the name COSA. Do you see those?
Yes.
And the text messages that say 4 gram now, 4 gram, 4 gram, 4 gram, $300. Do you understand those text messages?
Yes.
What do you understand them to mean?
He wants him to deliver 4 grams to the house.
He wants who wants who to deliver 4 grams to the house?
Mike was texting Kosa to deliver 4 grams.
And was that, in your experience, was that a rare or common occurrence for Mr. McCarthy, the defendant, to exchange that many texts in that short a time with COSA?
It was a common occurrence.
Your Honor, at this time, seek to introduce a record of calls from the defendant's cell phone number to the number associated with COSA between June 1st, calls and text messages between June 1st and the end date, I think, is June 30th, although I'll double check the end date.
So there's no objection? I'll admit that.
Let's do it. Back of this.
Exhibit 61.
Ms. Bond, showing you Exhibit 61 and the jury at the same time. Just so we're clear, the number 857-615-5482 belonged to whom? Is that the defendant's cell phone number?
Yes.
And the 305 number is the number you've testified is associated with COSA?
Yes.
So looking at this record of calls and text messages to and from those two numbers, do you see that, and this is from June 1st through actually middle of July, although I'm only going to direct your attention to a few days in June. Do you see 8 or 10 calls on June, or text messages on June 1st?
Yes.
Do you see then roughly the same number, maybe a few more on June 3rd?
Wow. Yes.
And then there's that period we talked about, which I'll come back to in a minute, between June 4th and June 17th when his phone was shut off. But do you then see 4 calls on June 17th?
Yes.
About 5 calls on June 18th, or calls or text messages on June 18th.
Yes.
I can't maybe estimate 20 or 18 or so calls on June 19th.
Yes.
4 on June 20th.
Yes.
Stuff here, maybe 10, 12 calls on June 21st.
Yes.
At least that many on June 22nd.
Yes.
Based on your experience in your life with the defendant, do those records surprise you in any way?
No.
This time, Your Honor, I move to introduce an exhibit, which is a printout of calls or text messages from or to the number 857-526-2792, which has been identified as the cell phone, to any of the numbers associated with COSA in the defendant's contact sheet.
There being no objection, we'll admit that.
This bond I'm now showing you has been marked Exhibit 62. I'm also publishing it to the jury. These are records of calls and text messages to and from the number associated with the cell phone, which is 857-526-2792, to any of the numbers associated with the name COSA in the defendant's in the contact section of the defendant's smartphone. You'll see. Do you see 4 calls or text messages on June 8th, 2015, to
Yes.
or from COSA?
Yes.
And who made those calls or text messages, you or the defendant?
The defendant.
Do you see a series of calls or text messages to and from the cell phone to the numbers associated with COSA on June 9th? Those are highlighted?
Yes.
And those calls or text messages continue on to the next page and are again highlighted. You see those?
Yes.
Do you see calls highlighted on June 10th on the next page?
Yes.
I'm going to skip ahead for the sake of time to the period. I'm sorry, maybe I won't. So we're still in that period between June 4th and June 17th when Mr. McCarthy's smartphone wasn't working. Do you see calls to the numbers associated with COSA on June 11th?
Yes,
And those are highlighted?
yes.
On the next page, a similar number of calls on June 11th?
Yes,
On the next page, a similar number of calls on June 12th?
yes,
On the next page, an even larger number of calls on, well, a similar number of calls on June 13th?
yes,
On the next page, a similar number of calls on June 14th?
yes.
And who was making those calls or text messages?
Michael McCarthy.
And based on, is this, well, so during the time that his smartphone wasn't working, he was using Dee's cell phone to call COSA?
Yes,
Your Honor, I provided defense counsel with the next proposed exhibit, and I believe there's an objection to that.
There's an objection?
So what it is, you need to see me at sidebar or?
Mr. Deacon just suggested that we go to the sideline.
Okay.
Only to protect defendant's rights. Your Honor, at this time I move to introduce excerpts from the defendant's cell phone, forensic examination of the defendant's cell phone.
No, my objection.
Okay, that's overruled and that's admitted.
Exhibit 63.
Ms. Bond, the defense counsel asked you a number of questions about your journal entries about Jade Helm this morning, I think it was.
Yes,
Do you recall that?
yes,
And I believe it was your testimony, correct me if I'm wrong, that the defendant introduced you to Jade Helm?
yes,
Did you hear him talk about it?
yes,
Did he talk to you about it?
yes,
Did you hear him talk to other people about it?
yes.
Who?
His brother, his father, Sprinsky, those people, those names go around.
This time I'm publishing Exhibit 63 to the jury, Your Honor.
And for the record, this is...
This is excerpts from the forensic examination of the defendant's cell phone. The first entry on Exhibit 63 is from Spirit Fire 53, Michael McCarthy. Are you familiar with Spirit Fire 53?
Objection.
Overruled.
Are you familiar with Spirit Fire 53?
I think that was a pseudonym or something for his name. I'm not sure. Emails. I don't know what it was exactly. I've heard of it, but I don't know exactly what it was.
Can you read, please, the first entry dated July 16, 2015?
Objection. She doesn't know what it was.
Okay, this is in evidence. The question is, can she read it? And she can, so the objection's overruled.
While Jade Helm is 15, has officially launched in the States. I would love to talk to you about this, but wasn't my original reason for reaching out to you this time. I don't know how I keep missing you. I'm not leaving the computer today, so I will have to get your response. LMA. Try calling now for the hell of it. Maybe you will answer.
And then there's a search items section dated July 26th.
Yes.
And what's that? What was the searched item there, the web searched item?
Jade Helm 15, Alex Jones.
Is Alex Jones the individual you had mentioned that he had shown you video clips on his phone from?
Yes, he's like a internet newscaster or something. Conspiracy, whatever.
On the next line down, do you see an entry for July 29th, 2015, a text message from the defendant's phone to Sprinsky?
Sprinsky, yes.
And can you read that entry?
All this Jade Helm 15 that the military is running operations in our country right now. They are flying helicopters, B-52 bombers, tanks being shipped in by the hundreds of thousands, if not millions, all different parts of the country, all over the place. Time to military, get everything you can imagine being shipped to every state, everywhere. People again on the camera.
Then ask you to read from line 15580 toward the bottom.
Yes. Hey brother, need advice urgently. I'm going to need your assistance in how to help Americans in this Jade Helm that we are experiencing. Please contact me as soon as you're not busy. Much love, brother.
And there are a number of searched items in that same exhibit.
Yes.
Do the text messages that the instant messages and text messages you see there, do they strike you, are they familiar or unfamiliar to you? I don't mean the specific message, I mean the content.
The content, yes.
Is it familiar or unfamiliar?
Very familiar.
Why is that?
He would talk about it all the time and do internet searches about it all the time with people recording the government shipping in weaponry, I guess, if you want to call it, in the United States. And Alex Jones would report on it all the time, Sasha Stone. There were a few that were on the internet that showed that stuff all the time, constantly.
Is this a good time, Ron?
Okay. Because we would like this juror to rest up, we're going to break today and resume tomorrow. Tomorrow will be a half day again. We would just hope that everybody is fit and happy and well to start at 9 o'clock tomorrow morning with my instructions not to talk about this case with anyone, not to do any independent investigation. So if you've heard something in the evidence that you have a question about, don't do your own internet search about that. It's very tempting. Do not do it. Also refrain from listening or reading any news accounts, and we will see you tomorrow at 9 o'clock.
Court, all rise, please. Jurors, you can step down whenever you're ready. Follow me, please.